Hello, this is John Milburn for LAWS 11059 Statutory Interpretation. This week we're dealing with week 7 material, Intrinsic Materials, the text. And it follows on from the first material that we've covered by way of introduction, creating legislation, interpreting legislation, our discussion of context and purpose in week 5, intention and interpretive techniques, intrinsic materials, the statutory components, and now we're dealing with the intrinsic materials, the text components. So this is week 7 material. By now you would have picked up a number of common themes, and one that I haven't specifically stated, but it's been implicit, is the value in having efficiency in words and conveying a message with a couple of things in mind. The first is that you communicate with the intention of informing the recipient rather than communicating for some other reason, such as to show how much use of words that you can make or how elaborate you can write. So simplicity and clarity is very important. It wasn't always the case in law. Some time ago, it would seem that the reverse was the opposite. And the longer the sentences, the more involved the text, the greater the number of words used, the more that the writer was to be congratulated. Now, with plain English or plain language drafting, foremost in legal logic, it's important that you convey your words in a very simple and clear manner. So where possible, communicate simply and communicate effectively. You'll see that reflected in the text in statutes now. If you look at statutes that were passed, say, 100 years ago, they're really quite difficult to read. Some that were passed more recently, such as one that I'm not terribly keen on, the Property Law Act 1974, still remain difficult to read. Have a look at, for example, sections 199 and 200 off the top of my head from the Property Law Act, and you'll get an idea of what I'm getting to. Other more recent pieces of legislation attempt to write in a very simple manner by looking at the text, and you have the best opportunity to understand what is said. However, occasionally, brevity leads to some difficulties in that you're left asking some questions about whether something was intended, whether something was omitted, whether something was included by mistake. In that regard, for example, look at the Domestic and Family Violence Protection Act, Queensland 2016. It gives you an idea of how the words are apparently quite clear, but when you read a number of sections in conjunction, it's not necessarily the case that you can determine with absolute clarity from the text alone what is meant in the relevant sections. So it's not black and white is part of the theme that I need to discuss with you. In other words, there's not necessarily going to be a right or wrong answer that applies in statutory interpretation, but applies in many aspects of law generally. So don't be concerned about having to create a response to a legal question or solve a legal problem with a requirement that you must get the answer correct. It may not exist. Many legal questions are based on purely hypothetical scenarios. So the view of the lecturer may not be correct. And when I say correct, I mean by reference to perhaps the more ultimate tests of what an appeal court would say about a decision that you make. Now, in a hypothetical situation, when you're writing a response to a legal question, then I guess as the marker, I'm essentially the appeal court and I make the decision. But I don't allocate marks specifically for getting the right answer on most occasions. And the reason I say that is that provided you go about the procedure of answering a legal problem, for example, by reference to the intrinsic materials in the text, in an appropriate way, and your methodology and legal logic is correct, you may complete 95% of the response exactly as I would, for example, but then in the last 5% take a different view than I would. In other words, you might conclude A, I might conclude B. Doesn't necessarily mean that you'll miss out on top marks. You could come to a completely different conclusion to me and still get 100% is the other thing. So conversely, when you're looking at the intrinsic materials, when you're looking at the text, part of the reason why I want you to read in greater context and consider the overall purpose, consider the act as a whole, as we say, is to avoid the trap of the simplistic answer. And it's easily done. You have a problem, you go straight to the section, and it proves to be incorrect. I'll give you one example I had recently in court, was agents applying to terminate a lease. And the termination was based on multiple breaches, Section 299 of the Residential Tenancies and Rooming Act, Room Accommodation Act, as the termination. But when you read that section, rather than just reading the heading, you'll see that it applies to particular circumstances, which almost invariably don't meet what the person drafting the application for termination had in mind. Have a look at that section and you'll get an idea of what I mean. And in that particular instance, it was clear that the applicant should have proceeded under, say, Section 293 instead of 299. Now, the reason I say beware of the simplistic answer is a very simple way of reading the intrinsic materials, the text, is to simply read the headings and the name of the section. A lot of people do that. If they're looking for an answer, for example, on termination of residential tenancy, find their way to the section that deals with terminations. They see half a dozen options and say, well, it must be that section because the heading looks like that's what caters for this scenario. So at a very simple level, looking at the headings is often not good enough. But then beyond that, regrettably, and not always the case, but regrettably at times, reading the section alone is also insufficient. And in a legal context, in law firms, paralegals, as hardworking as they are, particularly those, for example, who deal with conveyancing, they do a wonderful job, but they can at times be guilty of thinking in black and white terms. In other words, this is the part that I know, this is the section that relates to it, provide a response without looking at the bigger picture. So in studying law, in addition to looking at, for example, the entire act, you need to consider generally the bigger picture. That'll become more apparent as you work your way through the degree studies, where you start to see the interplay of things like equity and torts and contract law and consumer law, where in a particular scenario that's presented to you, whilst it might be presented in, say, the equity topic or unit, if you considered it, it may actually be relevant also to those other areas of law or other areas beyond those that I've mentioned as well. So simplistic answers need to be carefully considered. Thinking in simply black and white terms also needs to be considered. And I'll give you another example. You would have heard of the distinction between the law, common law as it was originally, which is sort of black letter law, and equity. And now, because we have the merger of both the original common law and equity into what we now call essentially the common law in total, it's easy to overlook different aspects of our legal system in coming to an answer to a problem or even interpreting that which is said within the text. And also be aware of the requirement to, at times, analyse material. What do I mean by analyse? It means look at it in a critical fashion and, in particular, determine what may be missing from the commentary. And if you adopt an analytical approach to reading statutes and think about whether this section may have broader implications or whether it may be affected by something else within the Act or the greater law or broader law generally, then you're starting to think in terms of a greater breadth of knowledge, and you're considering the interplay of a number of areas of practice. For example, if a section says this is the law, then when it comes to a dispute, an easy question that you might need to consider is, all right, well, if the section says this is the law and there's a dispute between two parties, who has the burden of proving the argument based on this section, this is the law? Is it the applicant? Is it the respondent? Normally it's the applicant or the plaintiff or the claimant, whatever it might be, but not always the case. So there may be a provision within the statute that has the effect of reversing the burden of proof. Another is, what's the standard of proof? Generally, in civil matters, it's on the balance of probabilities. In criminal, it's usually on the beyond reasonable doubt test. But is there some other provision that relates to the burden of proof, the standard of burden of proof, as well as the burden of proof? So these are the sorts of analytical questions that you might ask yourself as you're reading the text of a statute. All right, so of course, given that we're dealing with the text of statutes, which is a primary source of intrinsic material, where do we look beyond the text itself, and how do we read the text itself? So we know the difference now between primary sources of law, legislation and case law, and secondary sources such as textbooks. So there's a requirement at times to consider how all of this fits together. Just as an aside, I do encourage you to collaborate. Now, not collude, which is unethical and illegal and would potentially have you kicked out of the law school studies, but genuine collaboration is important. It's an important part of the overall course. It's an important part of this individual unit, and you can collaborate in a number of ways through the weekly sessions on Zoom, through Moodle, email, or through small study groups. And by now, in week 7, I hope that you've developed some contacts with colleagues and developed some small study groups. I'd be disappointed if you didn't try. Now, you might be disappointed in yourself if you don't try as well. And you might think, well, I'm new to law, so what would I be able to contribute? If you went in with that approach, I'd be disappointed as well. You may think that you don't have anything of value to offer, but I disagree with that. And even if you don't know some of the answers, don't be afraid to join study groups, because you might provide valuable contributions by asking questions or indicating that you don't understand this aspect. And it may be that when quizzed as to why, you have thought about different aspects that others may not have done. In other words, some of your colleagues who may, this is not meant to be a criticism, but some colleagues who may have a very clear and definitive answer may not have thought about other aspects, perhaps quite as widely as you have if you've got uncertainty. I hope that makes sense. So also bear in mind, if you've got a question, if you've got some difficulties, odds are that other students have got the same situation and same difficulties, so you can learn from each other as you progress through the unit. All right, so when you're reading the intrinsic materials and the text, Project Blue Sky and the Australian Broadcasting Authority tells us that every word has meaning. And Brennan CJ said, A court construing a statutory provision must strive to give meaning to every word of the provision. And that's really important because that's a starting point, isn't it? So when we're reading the text, it's important to consider every word, try to give it some meaning. And what meaning do we give it? Well, ordinarily, it's the ordinary meaning. In other words, whilst many words in our legal system do have specific interpretation that applies to them, for example, provocation in our criminal law, which may be different to the ordinary meaning of provocation. Ordinarily, when you're reading a statute, look at the ordinary meaning of the word. The example in your text relates to the word made. So there are issues where you need to consider the text, but do so within the context of what is being said generally. So an example in the book is Insight Vacations, trading as Insight Vacations and Young. It's 2011, 243 Commonwealth Law Reports 149. When we talk about Commonwealth Law Reports, CLR, we're talking about High Court decisions. Now, that case was interesting, and if you haven't already read it, or even if you have, place yourself in a situation where you're an advisor and a client comes to you and says, I want compensation for injuries I've sustained. Fair enough. I tried to get something out of my bag on the overhead rack in an aeroplane while I was on a tour bus and I was injured. The insurance company will not pay because they say the personal injuries insurance policy only applies when the person was wearing a seatbelt, and I was not wearing a seatbelt, but nevertheless, can I claim? So have a look at that situation and you'll see in that case, the High Court referred to the fact that ordinarily passengers do not have to be seated 100% of the time. Obviously, they need to get onto and out of the bus or the plane, whatever it might be. So therefore, even though the exemption clause contained the words with an ordinary and clear meaning, the ordinary meaning is the meaning of the words in the ordinary situation to which they refer. Now, that phrase, introduced by the High Court in Insight and Young, does not appear in the Act. Therefore, if we look purely at the text, and even if we look at the ordinary meaning purely within the text, we may fall into error. So catalogue that case, catalogue that line of logic, and be prepared to use it in appropriate circumstances. Remember, of course, that there may be technical or legal meanings used, and there may be, despite what I said earlier, a presumption at times in favour of a trade meaning, for example, in revenue statements. Also, there's the question of whether we mean something as it means now, as opposed to what it meant previously. For example, the word gay means something very different now than it did 100 years ago. So if we see a word in a statute, there are questions that arise. Do we mean that which is the current meaning, or do we mean that which was the meaning at the time? And another thing is the consistency of meaning. In other words, if we've determined that in a text there is a word used or a phrase used, and we're trying to interpret what it means, you might ask yourself whether that word or phrase is used consistently throughout the legislation. There's a general presumption that it is meant to be consistent all the way through. So one of the ways to test yourself is to ask, or what do I interpret this word or this phrase to mean? Is it used elsewhere in the legislation? If so, where? Now, let me apply the meaning that I think it should be attributed to the word in this other context, and does it make sense? If it doesn't, bearing in mind that there should be a consistent meaning throughout, possibly the meaning that you have in mind is not that which was intended and therefore is not that which should be used. It's often the test in courts where an argument is advanced about statutory interpretation, where someone is arguing that this is the meaning that should be ascribed to a text. The question then asked by the court is, all right, well, if that's the case, what about this situation? What about in those circumstances? What about if the plaintiff was from this class, etc., etc.? So there's a whole range of ways in which courts will go about testing the interpretation argument advanced by one of the parties. That'll do us for this session. Thank you for keeping at it, and we'll see you next time.